So whenever you are appointing an advocate for filing a suit or filing a petition or original petition or any complaint, there will be many circumstances where your advocate will have to contact you for the purpose of the suit, for the purpose of the proceedings in the suit. And there will be many small proceedings in the suit which are necessary for deciding the main case. And to decide a small proceeding, a small relief in the suit, or a relief which is necessary till the end of the suit, I'll give you an example in a couple of minutes. You need to file interlocutory applications. So interlocutory application is an application filed by the parties to the suit or the parties to the case in order to decide the main case. For example, you are filing a suit for perpetual injunction. So court has to decide the case by leading evidence, by deciding on evidence, by taking evidence from both the sides. And for that, it may take 5 years to 10 years or 2 years or whatever may be the time period. In the meanwhile, court must protect the interest of the party in whose favor there is more right. In a suit for perpetual injunction, generally it is filed by the party who is in possession of the property, who is the owner of the property. Injunction is an order that is required from the court in order to protect yourself from encroachment. So then court decides this question on an interlocutory application. So this interlocutory application will give you an order, court will give you an order till the disposal of the suit. And once the suit is disposed, once the case is disposed, this interlocutory application merges with the main relief or may be dismissed along with the main relief. If the suit is dismissed, interlocutory application is also dismissed. If the suit is allowed, interlocutory application relief will be merged with the main relief. Now, there could be circumstances where advocate has knowledge about the facts of the case. In that circumstance, the interlocutory application can be filed by an advocate. Another example could be the death of a party. When the advocate has knowledge about the death of the party, advocate himself can file an interlocutory application. Advocate himself can depose in an interlocutory application. So the sum and substance of this video is, whosoever has knowledge about the facts must depose. Remember this. If there is any error in the proceeding, court is conducting some proceeding in a different way by applying a different provision of law, then this fact which is happening in the court is in the knowledge of the advocate, not the party. Then advocate must file affidavit. Advocate can file affidavit. So the sum and substance is, the principle here is, whosoever he is having knowledge about the facts must depose. Sometimes file is returned. Then advocate has knowledge about the fact. Why the file is returned? In such circumstance, advocate must only file the affidavit. So the principle here is, in an interlocutory application, there is no need every time for party to sign the affidavit. Advocate can himself sign the affidavit. In some instances, even an advocate clerk can also file affidavit, is what the judgments which are in the description box says. So therefore, advocate can file affidavit in an interlocutory application. Party can file affidavit in an interlocutory application. Even an advocate clerk can file affidavit in the interlocutory application. The point is, only whosoever is having the knowledge of the facts must file the affidavit in the interlocutory application. Don't forget that. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.